Please be seated. We'll hear argument in 24-0040, Rush Truck Centers versus Sayre.
May it please the court, Mr. Grafton will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, the Texas Constitution requires courts to faithfully and consistently apply the laws of Texas. The courts must apply the laws the legislature writes based strictly on the statutory text. Here, the Dallas Court of Appeals opinion fails to follow the court's rules of statutory construction and ignores the plain language of two Texas laws, a product liability law and a venue statute, rendering portions of each meaningless. And it undermines the clear intent of the Texas legislature when it adopted these rules. I would refer to the court to Exhibit 1. The Court of Appeals erred by broadening the statutory phrase at the time the seller supplied in the non-manufacturing seller statute, section 82003, A6 of the Texas Civil Practice and Remedies Code. Looking at that statute, it is clear that the seller must have actual knowledge, not knew or should have known, but have actual knowledge of a defect, not an alleged defect, not a possible defect, not a missing option. And this knowledge, actual knowledge, must exist at a particular point in time. That is, the time the seller supplied the product. And additionally, there is a causation element to this cause of action. In 2021, this court acknowledged in Amazon.com versus McMillan that Chapter 82 was intended by the Texas legislature to be a liability restricting law. But the Dallas court's opinion does exactly the opposite. It expands liability of non-manufacturing sellers by holding the term supplied includes, and I quote, the entire sequence of events involved in making the bus available. This interpretation expands liability to any seller and any seller activity that arises.
We're not here to decide liability, right? We're not here to decide liability. We're here to decide whether all or a substantial part of the events giving rise to the cause of action occurred in the county in which suit was brought.
Agreed, Your Honor.
And the issue that you seem to be arguing are just the general venue facts applicable to both parties in the case, and not joinder facts or anything differentiating between the plaintiffs in terms of whether venue is proper. And the Court of Appeals took the case with the idea that it could reach and decide those facts, notwithstanding the provision that says that has to be done at the end of the case, and all but some exceptions. So would you address, please, the jurisdiction of the Court of Appeals to reach sort of a traditional venue argument as opposed to a joinder argument?
Your Honor, I believe you're referring to Section 1503 of the Texas Civil Practice and Remedies Code. As this court knows, this was amended in 2003 in response to this court's opinion in the
Let me ask you, you seem to be arguing that this section applies in any case where there's more than one plaintiff.
Correct.
Right? And so if that were true, then wouldn't it just totally do away with 15.064 that generally forecloses interlocutory appeals of venue determinations? Because in this situation, the multiple plaintiffs, the venue facts are the same. I mean, isn't it really talking about situations where you would have to, sever out things, you would have to have separate trials, you'd have to do all kinds of different things, and therefore you need to be able to make those venue determinations early in the process?
Your Honor, this is a case of statutory construction. The language is plain and it's clear. It says, and I quote, whether the plaintiffs are included by joinder, by intervention, because the lawsuit was begun by more than one plaintiff, or otherwise.
But you have to look at the statute as a whole. You don't look at text within, just this little area. You look at the context of
So,
the entire statute.
Agree that multiple plaintiffs may give rise to venue challenges under the statute 15003, but it says that the appeal may be taken under the subsection that a plaintiff did or did not independently establish proper venue. And so independently, what does that mean? Is it getting to the entire case, which is, I think, your argument, but which 15064 seems to belie? Or is it getting to venue differences among plaintiffs?
Well, I think the legislature was responding to this court's opinion that determined that this was a joinder statute and stated what it clearly stated. If they wanted it to be different plaintiffs with different claims, they could have added that language, and they didn't. And statutory construction rules require that courts do not add language that aren't there. And what the court
But the change just as easily could be read to say, we don't care whether you file suit on behalf of one plaintiff and then you do a petition and intervention for 50 more, or if you decide to sue at the outset with 51 plaintiffs. Either way, this statute is going to apply, to your point, to multiple plaintiffs.
Agreed.
But then the statute is only provides a narrow avenue of interlocutory appeal, which is to whether or not the particular plaintiffs among the multiples independently establish venue.
Well, we believe that all the plaintiffs in this case did not properly establish venue. And I would point out
So
that,
what are you left with for 15064 then,
well,
which is still on the
I
books?
take the legislature at its word. It wanted cases where there were multiple plaintiffs. If there was a venue ruling, any of the parties had the right to an interlocutory appeal. It says what it says, and it means what the legislature meant it to say. And it was clearly in response to the opinion of American Home Products case, where they viewed this as a joinder statute and wanted to limit it to those particular situations. And I would point out that the courts of appeals that have looked at this, of the 14 courts of appeals that have looked at this, 13 of the 14 have held as we are arguing it should be interpreted.
What is your answer to Justice Bland's question about the specific language of 15003, independently establishing proper venue?
You have to, I'm sorry,
15.003 references a plaintiff's, quote, independently establishing proper venue.
Yes. Well, in this case, there are multiple plaintiffs. They have different causes of action, and they have different, and they establish whether they're the same venue allegations or not does not matter, because the court did not, the legislature did not insert that. If they wanted this to only be limited to situations where there were multiple plaintiffs, they would have said plaintiffs that are asserting different claims.
Right, and so they didn't limit based on the numbers. I
Or
agree
different
with you.
grounds of
Number of,
venue.
it's the grounds, right? And the grounds are a trial court's determination that a plaintiff did or did not independently establish venue. In other words, you've got differences in venue facts.
Yes, I believe one of the courts of appeals addressed this, and I would refer the court to the Ramirez case, where they said that this was given a broad scope of interlocutory appeal, and the legislature's intent was to lie from every determination by a trial court in a multi-party case that a person seeking intervention or joinder as a plaintiff under Section 15.3 did or did not independently establish proper venue. So,
Don't we generally interpret interlocutory appeal statutes narrowly?
I think the court should apply the same rules of statutory construction to every statute, and this one says what it says, and it doesn't say that it's limited to certain situations where you have multiple plaintiffs making different claims on different venue allegations.
But if
And the
it's
courts of
possible to
appeals have so
harmonize
held.
the two statutes, we should do so, right? If it's possible to harmonize 003 and 064, we should do so and give them both effect, right?
Well, I think two things can be true at the same time, obviously. Yes, 15064 says you're supposed to wait until the conclusion of the case, except the legislature said, except in this situation. And the job of the courts is to follow the clear and plain language of the
Counsel,
statute.
I agree with that, and I thank you for starting your argument today with laws that had survived bicameralism and presentment. But let me start with a proposivist question for you.
Sure.
Would you agree or disagree with this statement? It would be a fairly unique and wasteful setup for a one sovereign's system of how it will operate its courts, that every single time somebody disagrees about venue, as long as you can count higher than one on a single side of the V, then always you can go up to a court of appeals. Purely as a policy matter, if you were a legislator arguing for a bill in the pink building over there, or the governor deciding whether to sign or veto something like this, policy, yes or no, terrible idea to say every single time you can go up as long as there's two on the front side of the V.
My position.
Yes or no?
I think the job, I think you should have that right if the legislature says you have that right.
Totally agree with you. We then have to get to what the text says, because that's what the law is and that's what we're supposed
Agreed.
to follow. But if there is any way that we can take this whole thing and read the later enacted and the earlier enacted and the fact that independently appears in various places in the statute, and so that's what are the normal, if you push back on the our precedent about narrowly interpreting interlocutory appeal jurisdictional statutes, what are the canons of construction or interpretive principles that I need to make sure that I write down and go pull the books off the shelf?
Well, the legislature is permitted to write laws that conflict. And this law does, I would argue, is in tension with the other law. But the legislature made an exception to the other one, and the specific would supersede the general. And because there's a general rule that says you're supposed to wait to appeal, there's a specific exception to that, which is the multi-plaintiff
So if it
plaintiff
was
situation.
a single plaintiff, we'd be under 15064. But
Agreed.
because we don't have a single plaintiff, we're under 15003.
Correct.
And that really does open, your position is that opens up an examination plaintiff by plaintiff of the venue facts. And each plaintiff has to independently establish it.
Correct.
And so then you do have to look at whether the venue facts are sufficient to establish venue.
I agree, and that's how
Okay.
13 out of 14 courts of appeals that have looked at this have so held.
If that were the meaning that the statute was conveying, though, it would be very simple just to say, if there are more than one plaintiff, a venue ruling is subject to interlocutory appeal. Instead, we have much more complicated language, including the remedy. If a plaintiff cannot independently establish proper venue, that plaintiff's part of the suit, et cetera, must be transferred, which is further text, which makes me think, when we talk about that plaintiff's part of the suit, we're largely thinking about when plaintiffs have something different from other plaintiffs. But when the plaintiffs have an identity of interest, can we not read this statute to say, well, that's clearly not applicable? It doesn't make any sense to think that this plaintiff's part of the suit. The plaintiffs have the whole suit together.
I think what the court is saying is that it would require you to add language that's not there. I think this language is broad to capture all the situations that you've raised in your questions. Where
Even
there are
situations where the pleadings and affidavits are exactly aligned. There's no daylight between the two plaintiffs in this case.
The statute says what it says, and I agree. If the court wants to offer dicta to the legislature or call up your state representative, I think that's the process.
Well, how about
to
if we
work
just
this-
interpret the word independently?
Well, then I would say that each plaintiff in this case attempted to independently establish venue. The Court of Appeals, the trial court made the wrong decision on that, and we're here to get resolution.
Do you want to talk briefly about the substantive issue? If you're successful in this argument, then you still need to be able to establish why venue in Dallas County was clearly wrong, I guess, or do you want to make that argument?
Well, I got 27 seconds, and I'm here to tell you that venue should not be in Dallas County. It's actual notice of a defect. The product was delivered. That's what I believe it should be means by supplied. That's a clear line. That's clearly when the risk of harm from using a product arises. That's good public policy. No one can sue for product liability until they're using the product, so that should be what the term supplied means. As it relates to the substantial part, the Dallas Court of Appeals interpretation renders that meaningless because it said anything involved in the distribution stream of the product.
So that may be too far. I would not concede, I think, that anything in the distribution stream would count as being a seller, for example, which is what supplied is connected to. But there are a lot of things that happen in Dallas County here, so we don't have to necessarily go all the way down to say anything in the distribution stream, any remote touch, in order to nonetheless say, in this case, Dallas County had an awful lot to do with this particular bus.
Well, provided it goes to the cause of action, which is actual knowledge of a defect. Doing a DOT inspection, putting letters on the side of the bus, issuing the title has nothing to do with knowledge of a defect at the time it was supplied.
Nothing to do with it? I mean, this is where the bus is inspected. I mean, for venue, for just based on the allegations at the beginning that a plaintiff brings, we're not talking about proof and all that stuff, and I get it. That's one of the complicated things, is it may well turn out that venue is proper at the beginning, and that's what we're going to do the trial, whereas at the end we realize, well, none of this actually happened. That's what a final judgment is about. But at this early stage, is it really that implausible to think that the things that happened in Dallas County, the inspecting, the titling, the taking delivery, the equipping of the bus, that would be the place in which the defect, if one was known, obviously you disagree that one was known, but that's not the stage that we're at in this case, would be in Dallas?
I would argue that they didn't sue RTC for improper DOT inspection. They didn't sue them for improper titling or delivery.
But those are the places where, and I won't belabor it anymore, just one more thing. That's where it would seem to me that they would say, well, that's why they have the actual knowledge of the defect. This is the county in which all of the places in which they would have knowledge of the actual defect, and then where they actually did sell it. That's where the titling took place. Why isn't that enough for venue? That's my last question, I promise.
Well, because the issue is knowledge of a defect, and the only person that has evidence of the record that knew what specification was for the bus, knew what features were on the bus, knew what was not on the bus, was the salesman who sold the bus in consultation with the customer. And that gentleman, Mr. Reuben Koenig, lived and worked in Parker County. So if the element that's required is knowledge of a defect, there's zero evidence of anyone else at RTC besides Mr. Reuben Koenig that had any knowledge about the features in that bus. And as a result, Dallas County and these clerical and administrative functions, albeit relevant, are not substantial. The statute says substantial. The legislature thereby clearly said that there can be events that are insubstantial as well as substantial. And when the court is supposed to focus on the substantial, the ones close nexus, connected, core, indispensable to the alleged allegation, which is knowledge of a defect at the time it was supplied. I've used some of my time. I thank the court. I'll be back in a few.
Any further questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Levenger will present argument for the respondents.
Mr. Chief Justice, and may it please the court. I think this court was absolutely right to flag the jurisdictional issue for further briefing and discussion. I think it's important to the jurisprudence of the state, and I think, frankly, the courts of appeals have just been getting it wrong and sort of broadly taking the position that just because you have a multi-plaintiff case, you automatically have interlocutory appellate jurisdiction. And I know it might be unusual for the party who won in the Court of Appeals to now be arguing that the Court of Appeals lacked jurisdiction, but I think that's the right result in this case and in any case in which the plaintiffs are indistinguishable for venue purposes, as they are in this case. I think it's useful to think of it this way. If the deceased child here had one parent or only one parent who brought suit, there's no question that they would not have an interlocutory appeal. They would have to wait until the end of the case to appeal from the final judgment. Why should it be different that this child has two parents and two parents who filed suit? I think
Guess they might say, well, each parent is suing for their own damages.
maybe, but I think fundamentally.
Is that true, or do the parents have, I assume,
They do.
independent? Okay.
Yeah, they do. They have different wrongful death damages, for sure. But for venue purposes, I think they're indistinguishable with respect to the cause of action. The jurisdiction, I think, if you want to look at the statutory language, it really turns on two words. The court has talked about the word independently. I think it also depends on the word determination. Did the court, in fact, make a determination that a plaintiff did or did not independently establish proper venue in that particular county? And based on that plain language, I would submit that interlocutory appellate jurisdiction does not lie when the trial court is not asked to make a determination whether each plaintiff did or did not independently establish venue, when the trial court does not make such a determination, and when it's not necessary for the trial court to make such a determination. That would be my test for when there is or is not appellate jurisdiction. And that's our case. The two plaintiffs are indistinguishable for venue purposes. The movement in the motion to transfer venue never distinguished between the two. They just treated them as one for all purposes.
You know, the benefit of your friend on the other side's reading is that it does seem to conform to at least the first part of the statute, and it's simple. All the courts of appeals know pretty clearly whether they have jurisdiction. And the downside of the reading that you're advancing, that we explored in the first part of the argument, is we're now going to have to figure out in cases what is sufficient, what does independent mean? Well, is it just because they have different damages, is that enough to be independent, in which case you've just acknowledged that it would be, I suppose? Or is it something where it's a different kind of claim, and there's going to be an awful lot of litigation about, satellite litigation about this statute? Why not just take it at its face and that initial impression and let the legislature fix it if it wants it to be something other than that?
I thought about that, Justice Young, and I think the answer is because the courts of appeals have just been getting it wrong in saying that every single multi-plaintiff case necessarily involves a determination of independence.
How long have the courts of appeals been getting them wrong for?
Well, the statute was enacted in 2003. I think you started seeing opinions come out in about 2006.
All right, so we've had from 2006 and we're now in 2025. Have we seen the legislature rise up and say, well, for crying out loud, that's not what the statute meant?
No, we have not seen that.
So is it legislative acquiescence might be too much to say exactly, but if this were really something that's been uniformly done across the state, and the legislature, that's not what it meant, wouldn't we expect to see at least some action from the legislature to pare that back?
Well, the problem is it's rarely raised. I'm guilty of that in this case. I just assumed when I looked at it that there was interlocutory appellate jurisdiction because we had multiple plaintiffs, and that's what the Court of Appeals said. But on reflection, encouraged by this court, I might say, who flagged it for our further attention, I looked at the statutory language, determination.
What makes it worse, and my condolences to your clients, this is a horrible case, and you're getting drugged through both sides, all of this process over venue. And what makes it even worse is that venue originally was intended to be a matter of convenience for the defendant. And now it's become a matter of politics and whose juries are more likely to be pro-plaintiff or judges. If the legislature's going to address this, they need to address venue at a much bigger scale. But be that as it may, we've got what we got in the language of the statute. And we don't have to construe it to be absurd, but we also can't construe it differently just because it doesn't make sense or isn't the best policy from our perspective. And it just seems to me pretty clear. This says, 064, you can't have an interlocutory appeal on a venue determination. 003, if there are multiple plaintiffs and the trial court makes a determination of venue that a plaintiff did or not independently establish proper venue. Well, that's what the trial court did here. The trial court here made a determination that a plaintiff didn't independently establish venue. And so I hate to see you guys go through this, I honestly do. And I wish the legislature would fix this whole venue thing from a much bigger perspective. But I just don't see how your argument can get us around the plain language of the statute.
Well, I appreciate that, and I think the key words here are determination and independently. The trial court here was not asked to make a determination as to whether a plaintiff did or did not independently establish venue. The argument was generic as to both plaintiffs, indistinguishable. The trial court denied their motion to transfer venue, but it did not make a determination that a plaintiff did or that each plaintiff did or could independently establish venue. And it was not necessary for them to do so.
The problem with conceptualizing it that way is what 15.03A says at the top, which is that each plaintiff has to independently establish venue.
Right.
So even if there's no difference between the facts that are relevant to the plaintiffs, there's no difference between the venue arguments, in theory, each plaintiff is independently establishing venue, the way this statute seems to be structured. And then, in theory, when the court makes a ruling, it's making a ruling as to each plaintiff independently, even if the arguments aren't different. That would be one way to read all of this.
Right. I guess we're dealing here with the extreme case. The venue theory is absolutely the same. The plaintiffs are indistinguishable. Now, I'm not here saying that interlocutory appeals lie only when you have different plaintiffs with different claims and different venue theories. I'm not saying that. That may be, of course, one situation in which you do have an interlocutory appeal. But I can think of a case where you can have multiple plaintiffs asserting the same claim and the same venue theory, and there would be an interlocutory appeal. A good example is a case called Double Diamond versus Alfonso, where the Court of Appeals out of Corpus examined each plaintiff independently because their claim was a fraud claim. And each plaintiff had independently established a linkage between the fraud claim and Hidalgo County. What was unique about that case was the elements of the claim were plaintiff-specific, fraud, defamation, that sort of thing. The claims here are not plaintiff-specific. It's a negligence claim against defendants.
If we end up going the direction that Justice Boyd is suggesting, which is that when you look at a particular plaintiff in a multi-plaintiff case, you are asking whether that plaintiff established venue. What are your arguments to support the Court of Appeals' determination in this case that venue was proper?
Yeah, turning to the merits, it's interesting. They told the trial court that this is a straightforward case, and I agree with that. The problem is their arguments as they progress to become more and more kind of convoluted and result-oriented. I think it's very simple. I mean, you start with the fact, as Justice Young said, that a substantial part of the events and omissions that led to this little girl's death in Parker County took place in Dallas County because...
Can you walk us through exactly what you're referring to?
I'm sorry?
Can you walk us through exactly what you're referring to?
Sure. So Rush Truck does business as Rush Bus Center Dallas, has a facility on Irving Boulevard in Dallas. At that facility, and this is all going to the word supply in section 82.003A6, that they have to supply a bus with knowledge of the defect. The supply took place when they ordered the bus out of Dallas, they took delivery of it in Dallas, they equipped some of the options in Dallas, they had it inspected by the state in Dallas, they registered it in Dallas, they titled it in Dallas, they invoiced it out of Dallas, they collected payment in Dallas, and they delivered it from Dallas to Brock Independent School District. Those are substantial events that led to her death. Now,
And did I see somewhere that title transferred in Dallas?
title transferred in Dallas.
Just to the school district?
To the school district, right. And that particular title shows the previous owner as being RBC Dallas, or actually Rush Truck DBA RBC Dallas. And each of these events give rise to the particular cause of action upon which we're relying for venue purposes. It's 8203A6, which involves supplying a product with knowledge of the defect. So I think the key statutory word is supplied, which is certainly broader than sold. And everything I just mentioned is integral to supplying that bus.
So their argument seems to be that the defect was something that arose because of what the salesperson did in Parker County. Can you respond to that?
I think what they're addressing is the knowledge element, and several answers to that. First of all, I don't even know that the court needs to get to knowledge because you don't need to show a linkage between every element of a cause of action in the county. We certainly have a linkage with the supply element, but going to the knowledge element, there was evidence that Mr. Reuben Koenig, who was the sales representative doing business for RBC Dallas, all the documents show him as their sales representative. He had a visual impairment, which required him to office out of his home, happened to be in Parker County. So he was dealing with his counterpart at Brock Independent School District in Parker County. He testified that he knew about safety devices that were available for these buses that would protect children in the so-called zone of danger, the 10 feet in front of the bus. And he knew about crossing gates, which swing out and require the children to go out, so they're out of within the line of vision of the driver. And he said, I know about those, and I know this bus didn't have them. So that's knowledge of the defect. Now, remember, he's not the seller. The seller is RBC Dallas, and his knowledge is attributed to RBC Dallas, which held him out as their sales representative. All the documents are signed by him, or many documents are signed by him as RBC Dallas's sales representative. Also, the evidence, and remember that we're here on venue, we're not trying to prove our case and didn't have to prove our case, but the evidence showed that RBC Dallas itself knew about the defect because they had an inventory of buses that did have the safety features that this bus lacked. Cameras, pedestrian warning systems, crossing gates, and the like, and they knew this bus didn't have that. Even though they were at the RBC Dallas facility, were installing certain options. They didn't put this option on it. So I think that more than satisfies the knowledge element. Throughout their briefs, they make an effort to sort of exclude from the court's consideration all these events that happen in the middle. And I think the Court of Appeals had a good analogy. They said, you're focusing on the bookends, the negotiation on the one side and the delivery on the other, but you're ignoring the books. And all those books were essential and an integral part of the supply element, because the negotiations, which arguably took place in Parker County, although the order came out of Dallas, the negotiations would have been meaningless, and the delivery would have been impossible without all these steps that happen in the middle that I talked about earlier, the ordering, the delivery, the titling, and so forth.
It seems as though your position is that a sales representative working remotely shouldn't be considered for venue purposes if they're doing it on behalf of their employer. But I wonder whether if you were trying to establish venue where the sales representative was, you would be arguing the exact opposite. So I'm just wondering, we have so many employees that work remotely out there. Is their location and for remote work a venue fact that can establish venue either in their location or the location of the employer, or is it really they're working remotely at the behest of the employer in a particular county?
Well, if he actually officed in Dallas, that would be one more fact, I think, in my favor, but I wouldn't be ignoring either way what he knew or what he did. I'm just simply saying that his knowledge is attributed to the seller. He's not the seller. His knowledge is attributed to the seller, and the documents show that he would sign documents as a sales representative for RBC Dallas. It's just an imputation issue. That's all I'm saying. So it really doesn't matter where he works. The question is he claimed by that facility? And the evidence showed from the documents he signed that they held him out, and he held himself out as a sales representative for RBC Dallas, which, as I said, officed in Dallas. I want to talk about, at the beginning, counsel mentioned that we're somehow reading words out of the A6 statute. I think what he's referring to is the words "at the time." Not reading those words out at all. I'm simply saying that the knowledge can occur anywhere along the events that lead to the supply. The purpose of the words "at the time" in 8303A6 is to make sure that sellers not held liable for after acquired knowledge, for knowledge they acquire after the sale. So we're not reading those words out, we're giving them the meaning that they're intended. There's also an argument they make to the effect that, well, the heart of the case is where the sales representative, Mr. Reuben Koenig, could have disclosed the defect. They talked about the time at which he could have shared this knowledge with Brock Independent School District. they're focusing on the wrong cause of action. That's an 8203A4 cause of action, which we have asserted, which involves non-disclosure. I'm talking about, for venue purposes, 8203A6, which does not have a disclosure aspect to it. So I think that's the wrong focus. I believe that completes my argument, unless the court has any further questions.
Any further questions?
Thank you.
Thank you, counsel. I believe you have 5 minutes.
Thank you, Your Honor. I want to address the jurisdiction issue just quickly. I would point out that each parent has a claim, the estate has a claim, and 2 siblings have a bystander claim. So there are independent claims, multiple parties. As Chief Justice Blacklock said, this issue, regardless if they're all the same venue allegations, has been addressed in Jackson v. Jackson, Texas Fort Worth Court of Appeals opinion, and a Dallas Court of Appeals opinion, the Stauffer case, Union Specific, and they held in multi-plaintiff cases, every order on a motion to transfer venue will necessarily determine whether each plaintiff did or did not independently establish proper venue. So when the court issues an order, it is addressing the independent determination.
Counsel, could we go back to, you kept first things first when you were first up at the podium, and it's appreciated.
Sure.
So you'd mentioned, we didn't get like a color-coded, these are the things that your friend in opposition is trying to put into the statute.
Yes.
And so, but I understand that you would characterize your friend in opposition's reading of 15.003 as trying to put some words in that weren't there.
Correct.
But if we're going to look at this thing through an empty paper towel tube or something like that, if we do it that way at 15.064A in the last sentence there, no interlocutory appeal shall lie from the determination, and that from the first clause of the first sentence there, in all venue hearings. So if we were looking at that, we got a no, and then we have a later enacted, so we clearly can't just stop with that, but we also can't just stop with what we find in 15.003 as amended in 2003. And so can you help me understand, what are the canons of construction that you would have us go and take a look at? Because we can't just look at the last sentence in 15.064A, but we also can't just look at this or that thing plucked out of 15.003A or 15.003B.
I believe there's canons of construction that say that general rules or
Specific
statutes
governs the
are
general?
superseded by specific.
Okay.
So the first one, 15064, is a general admonition by the legislature, but 15003 is a very specific one for specific situation. If I may, Your Honor,
But you said we shouldn't apply our understanding that we narrowly construe interlocutory appeal statutes, and why is that?
because the language of the statute is the language of the statute, and it says what it says, and
Well, and so does 15064.
Except when it doesn't, and we'll use canons of construction to
Construction that
decide
says-
when it doesn't. So I have my pen out and I'll make the noise. Do you want me to write down anything else besides specific governs the general?
no, Your Honor.
Great, thank you.
Your Honor, I do want to address the knowledge issue. If you look at Exhibit 5 that I've attached, it is sworn testimony that's in the court's record that makes clear that Mr. Reuben Koenig testified that this bus complied with all federal law, it complied with all state law, and that he thought this bus was safe. There is no knowledge of any employee at RTC of a defect, period. But to the extent there was one employee that was closely connected or had some nexus to the element of actual knowledge, it was him, and he worked in Parker County and never worked in Dallas County. I think it's
So are we to attribute, for venue purposes, the location of a worker's workday as opposed to the location of the employer when talking about venue facts? Because I think a lot of employers would not like that rule because it might subject them to venue anywhere throughout Texas as opposed to where their operations truly lie.
in many causes of action, I think that's true, but the statute, the cause of action is actual knowledge. And the only person who had actual knowledge of anything in terms of features that's before this court is Mr. Rubenking. And I would point out that Mr. Rubenkenig's boss is in New Braunfels, not Dallas. He was associated with Dallas for paperwork purposes. He had 2 administrative assistants because he was visually impaired, and the testimony is he doesn't know which one helped him type up this proposal.
Would venue be proper in Comal County then?
Yes,
since his
because
boss is in New Braunfels?
that is the principal place of business for RTC. That would be a proper venue. Your Honor, I would be remiss if there's one thing that I do want to mention is the Court of Appeals in Dallas erred when it found that RTC did not specifically deny certain venue allegations and they were presumed to be true. They're wrong for 3 reasons. First, in the petition, there was a section identified as jurisdiction and venue. There was a section identified as facts. There was a section identified as causes of action. RTC specifically denied every allegation in the section labeled jurisdiction and venue. What the Court of Appeals did was grab allegations from the general section of the petition and say you did not specifically deny those. Therefore, that establishes knowledge by RTC in Dallas because they were not specifically denied.
Counsel, your time has expired. Thank you very much.
Thank you, Your Honor.
Are there any further questions? Thank you, Mr. Grafton, Mr. Levenger. Thank you to all counsel, and thank you to you and your clients for addressing the jurisdictional question that the court raised. The case is submitted, and the court will take another brief recess.
All rise.